President.
Good evening, everybody. I'd like to call to order tonight, February 10, our special town board meeting. Would everybody please stand for the Pledge of Allegiance? I pledge allegiance to the flag
of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all.
Tonight is a workshop for us, for the town board. We don't get to do business together, except if we're in public, and we've spent a lot of time listening to comments, and I think we all have some questions that we want answered. So we've called this workshop for us. I'm inclined not to take questions and comments from the public, and I just wanted to see how everybody else feels about it. It's a workshop for us, and we'll announce tonight a continuation of a public hearing, I think, at the end of this. Alan, Joe, you're all right with that?
Yes, I think it's
Okay. I'm going to turn this over to John Lyons, but I guess three things. I'm kind of hoping that we can have a brief overview of this mining overlay from 2008 to just before the comp plan to now, and why we're here, and questions I have, and if anybody else has. A discussion of concern raised by the neighbors group regarding traffic, possible traffic on the road and bridge, if there were to be additional large-scale mining, and can we do anything to mitigate these concerns? And another question I have is that there were issues raised by Mr. Vonderleeth and his supporters in the December public hearing, and I want to know how this proposed zoning amendment affects his mine. Joe, Alan, Bruce, if you want to state your questions now, or if things come up.
As things come up.
Thanks, John.
Thank you, Elizabeth. My name is John Lyons. I'm a lawyer with the law firm of Grant and Lyons, and we are assisting the town board in connection with this amendment. And this workshop session follows on the heels of the first session of the public hearing, which was held in connection with the proposed amendment. It was held on December 8th. And the purpose of this workshop session is, as Elizabeth mentioned, to have an opportunity to discuss the first level of information that emerged from the December 8th public hearing. I know that all of the town board members are interested in being very careful about proceeding. I know that they take very seriously the concerns that were raised at the public hearing, and so this workshop is a step in the process of trying to process that information and look ahead to where the next steps are. So this evening we're going to be talking about three topics. I'm going to lead off I think in addressing the question that's been raised about the impact of or the potential impacts of the proposed amendment upon Richard Vonderleeth and the mine that he operates in the town. You'll see over on the side we have on the poster board a map which town board members have seen before, and this map, which was developed by the Dutchess County Planning Department with some information that was provided by Mark Rominski, which he developed from the town. And I'll just recap that this map, the red lines that are shown on this map indicate the mining overlay amendment district boundaries as they exist at the present time. The brown cross-hatching that's shown on this map depicts the proposed new mining overlay district boundaries. and these boundaries were calculated to coincide with the life of mine boundaries for the 3 DEC permitted mines that are in this area. The mine that is operated by Red Wing Properties appears at the top. The Labatsky mine is right here in the center, and Mr. von der Leest's mine is the one that appears to the south. I thought at the public hearing session that was held on December 8th, Mr. von der Leest appeared, and he also, there's a letter that's in the record before the board that was really a letter by Mr. von der Leest to his fellows in the community that was expressing his concerns about the proposed amendment and asserting that that he believed that if the amendment were to be passed, that it would put him out of business. And at the December 8th public hearing, Mr. von der Leest appeared, and also, I believe, his daughter Kelly, and they discussed their concerns about that. There were also, many people spoke that evening, about 30 people, and a lot of information got bandied about in front of the board, and lots of things were said. And so one of the reasons that we're taking this step today is to try to, is a step on the part of the town board to try to make sense out of that information, to figure out what the answers to the questions that were raised there really are. So I thought that the best way for us to discuss this tonight is just for me to take you through very briefly the information that has been submitted to the board in connection with this issue regarding the impacts upon Mr. von der Leest's mine. And then I think that what's happened is that the information that we've gotten so far has provided the town board with some information, but it's also raised a series of questions, I think, that need to be addressed before you're in a better position to really make an informed decision about the potential impacts of the mine on Mr. von der Leest's operation. There's I referred to the letter by Mr. von der Leest, and that's a November 18th, 2014 letter. It's in the record. Again, it was kind of an open letter to the community, but I think it was also directed to the town board. And Mr. von der Leest indicated in that letter that without the ability to expand, he said that without expansion, we're done. He was very concerned that your children's future can be taken away overnight. He did also mention in that letter that there's a beef cattle operation on this property, and he indicated that there are 30 to 50 head of cattle in connection with that operation. We then had the public hearing on December 8th, and I talked just a few minutes ago about the testimony that was offered at that public hearing and the assertions that were made on both sides of this issue. On December 15th, the town board received a letter from Stephen and Patty Labatsky, which also made some assertions about the impact of the proposed amendment on the von der Leest mine. Mr. Labatsky asserts that Mr. von der Leest's business is diverse, involving cattle, excavating, mulching, and mining. And he asserted further that even if it was true that the mining amendment would preclude him from mining, that it would only affect a portion of what is a range of businesses being conducted by Mr. von der Leest on the site. Subsequent, there was a document that was submitted to the town board, undated, by Paula Trimble, which discussed Mr. von der Leest's property and made some assertions with regard to his ability to mine further on the property. Her letter specifically dealt with this area outside of the Vonderleeth life of mine boundary, but still inside the mining overlay district boundaries. And Mrs. Trimble's assertion was that according to the Dutchess County parcel access environmental map layers, that this area is pervaded by New York State and federal NWI wetlands and would be very, very difficult or present difficulties for mining in the future, even if Mr. Vonderleeth were to desire to expand into that area. Mrs. Trimble also pointed out that there are other properties that are owned by Mr. Vonderleeth in this area, but in her letter she identified those properties and asserted that those properties exist outside of the boundaries of the mining overlay district, with the result being that they're not really available for expansion of mining operations even at the present time because of the current district boundaries, and that the proposed amendment wouldn't make any change. Another point that I did want to make just as a kind of a baseline is that the proposed amendment would not have any impact on any of the existing existing permitted mining operations. But getting back to the information that that has been submitted to the town board, there was also submitted to the town board copies of mining inspection reports that were conducted of the Vonderleeth mine by mining division inspectors of the State Department of Environmental Conservation. And those were submitted to the board by counsel for a group of the neighbors that live in the area that may be affected by the amendment. And those reports indicated that the primary activity that appears to be taking place on the Vonderleeth mine has to do with the processing of material as opposed to excavation, although those mining inspection reports are periodic, and I think, additional information is something that would be desirable. And that leads me to my next point, which is that these facts, I think, are very useful to the board, and I think they are helpful to you in getting to a point where you can make an informed decision about the impact. But I think that this information really does is it raises some other questions. I think that in an ideal world, it would be good to have answered, and I think the information answering these questions would be best obtained from Mr. Vonderleeth himself. When he spoke at the hearing, or at least thus far, he has not provided a lot of details. But it might be helpful to the board if he were able to provide to the board on the public record more details about the impacts as he sees the impacts that are concerning him. And I just wanted to go through some of the questions that are raised by the information that's been submitted thus far. And I guess, one question is, what's taking place right now on the Vonderleeth mining site in furtherance of the existing DEC permit? Is it just processing? Is there excavation being done? And if so, what's the scale of that activity? Is there just surface mining taking place here? Does Mr. Vonderleeth have the ability to do subaqueous mining, which would be providing him with an opportunity to expand his mining operation without going outside of the footprint of his present life of mine boundaries? And I believe that type of mining is being sought by, I think Red Wing Properties has a permit from DEC to do that very type of mining up on their site. There's a question also about expansion has been discussed, or at least mentioned by Mr. Van der Leef, and I think it would be useful if more details could be had from him about what it is that he's thinking about with regard to expansion. In his mind, does expansion mean pushing out into this other area of his property that's within the mining overlay boundaries? Is expansion, is it something that he's thinking about with regard to these other properties that he owns in this vicinity? And related to expansion, it would be also good to find out what his take is on whether this area of his property can be mined because of the natural resources constraints that may exist in that area. I think the last thing that would be beneficial for the board to understand has to do with the layers of his business. If it's true that his business is not just mining, but also encompasses excavating and the farm and perhaps processing of materials, it would be beneficial to the board to understand how mining fits into the fabric of the larger group of operations that Mr. Van der Leef is conducting on this site, and how much of the, what slice of the pie is the mining operation. So these are all things I think that they're good questions, and I know that you're concerned about being able to make an intelligent and fair decision, and I think this information would be very helpful to you. The board is not in a position to compel Mr. Van der Leef, obviously, to submit information to you, but I think that through this meeting today, we can make it clear that the submission of that information certainly would be encouraged and appreciated, so that the board can have a fuller understanding of the assertions that he's making and the potential impacts on his operation, and an understanding of what he is doing on that site. And if you have questions or you'd like to discuss anything on that, we can do that now, or we can move on to, if you want to have your discussions later, we can move on to the second topic that is on our list.
I just have a question. What step could we now take to get that information?
I think we can invite Mr. Van der Leef to provide that information, and so that it goes on to the public record.
Okay.
That the town board is assembling in connection with this matter.
Do we need to vote on that, or?
No.
No.
Okay.
Anyone else? Okay. The second item on the discussion list for this evening has to do with a discussion of the history of the mining overlay amendment and the history of the mining overlay district, I guess is a more pointed way of saying it. And we have with us this evening Ted Fink, who is a certified planner and who was one of the planners to the town during the time that the town rewrote its comprehensive plan and rewrote its zoning law, the efforts of which culminated in the 2009 comprehensive plan and zoning law that are now the zoning law and comprehensive plan of the town. And there's been discussion about that history, and we thought that it would be a good idea for Ted to come forward and to, having been present at the time, to tell you a little bit about his recollections of that history. And I'll turn the floor over to Ted.
Thanks, Ken. Well, as John said, my name's Ted Fink. 12 years ago, the town hired me to help them undertake the preparation of a whole new comprehensive plan, a new zoning law, And also what was thrown into the mix was new subdivision regulations for the planning board, as well as a freshwater wetlands law.
So you were retained in 2002?
2003, it was, I think it was
2003.
February of 2003, so it's 12 years ago. Almost 12 years. But I was one of the common threads here. I think I was present at virtually all of the meetings, and there were hundreds, literally hundreds of meetings that were held. First by a comprehensive plan committee. Then there was also a zoning committee that was a subcommittee of the comprehensive plan committee. Then that morphed into a zoning task force. And then, of course, there was the town board. So there were 4 different groups that worked on this effort. And in addition to the hundreds of meetings, we had visioning sessions. We had 11 different visioning sessions where we reached out to different groups in the community. We went to the civic groups. We went to business groups. We went and we talked to the realtors. We actually went into the schools. We had elementary school kids come in here to town hall, and they made a presentation on a little survey that they had done about how they wanted to see the future of their community. We did everything we could. It was certainly the most comprehensive public outreach effort that this town had ever done. It may have been one of the most comprehensive ones ever done in Dutchess County, and Roger Akeley, who was the former commissioner of planning, had some remarks about that. But and on top of that, throughout the process, because it went on for basically 7 years, almost 7 years, we had 3 different town boards that we dealt with. There was the original one that started the process in 2002, where they appointed a committee, and I came along in 2003. Then we had another town board that came along, I think, in 2006, then 2008. And then finally, there was a real push to get everything accomplished before a 4th town board came in. And I think that was you, Joe, and Gina Fox, came in on January 1st, 2010.
Yes, that's true.
Right. So that was just a little bit of a history of that. But in terms of the actual planning effort, we had 22 members of the Comprehensive Plan Committee meeting twice a month, and they came up with a document. It went on probably 400 or 500 pages in 2006, and that document had specific recommendations on the environment and specifically on mining. And the recommendations that were in the 2006 draft plan at the time are the same ones that wound up in the 2009 document that was adopted. And I went back and I compared the two, and the actual recommendations remained the same. But just to give you a sense of all that went into it, it wasn't just the committee, but we had a public opinion survey that was done of the town. There was 3,500 surveys that were sent out in the town. We got a response rate of 764 people. So we had a really good cross-section of the community that responded to the survey. And we asked a whole variety of different questions about the environment and about business and about where do you want to see growth and how do you see the future of the town. And overwhelmingly, the community came out and said that they wanted the town to stay as it is. They wanted the town to protect the rural, historic, scenic, and the natural character of the community. And that wound its way into more than 400 separate recommendations that went into the whole comprehensive plan, many of which were then directly translated into changes to the zoning. So it was really a comprehensive rewrite of the zoning to try and address as many issues as possible from the comprehensive plan effort. We actually had 3 different planning firms that were involved on this, and 3 different law firms that were involved on the process. Throughout this process, because so many of the recommendations were, while there was overwhelming consensus and an overwhelmingly positive attitude towards the direction that the town was going in, with both the comprehensive plan as well as with the zoning, and that was based on workshops that we had, and public information meetings, and public hearings. I don't even know how many public hearings we had, but there were quite a number of official public hearings throughout the process. We had a number of different groups that came forward, represented by different attorneys. When I counted up, there were probably about 10 different attorneys representing different groups within the community that came forward. And there were big projects involved. There was Holy Cross development at that time. There was Michael Jesselson and his 1,250 acres, the biggest landowner in the town. We had the gun club. There were serious issues revolving around the continued operation of the gun club and its effect on neighbors. There were the large landowners along the Hudson River that were potentially affected. And then there were smaller ones too, some individuals that were concerned about various aspects of the plan. But we distilled all of the potential impacts of the comprehensive plan and the zoning law adoption into two different secret documents. One was a draft generic environmental impact statement, and then we had a final generic environmental impact statement. And we looked at a wide variety of these different competing demands between what the citizenry of the town had expressed and trying to balance that with some of the concerns that had been expressed by individual landowners. And we looked at 7 different alternatives to try and address all of these things in as complete a way as we possibly could. And so that was sort of the overall context of the different parts of this process that we went through. But as far as the mining was concerned, when you look at some of the recommendations that were made for protecting the rural, the natural, the scenic, and historic character of the community, we had recommendations in the plan that grew out of all of these different sessions and the surveys and so forth, such as that businesses should serve local needs, that we should be protecting things like agriculture, forestry, open space, scenic landscapes, water resources. We should conserve biodiversity and wildlife habitats. And with regard to new businesses, we should both be encouraging existing locally owned businesses, but for new businesses that wanted to establish themselves within the town, that those should be, and this is a quote, built to human scale and provide for residents' needs. So that was the overall sense. The sense of the comprehensive plan, the sense of the zoning was, we don't want to stop development, we don't want to stop businesses in the town, but we want to do is we want to make sure that all of the new projects and the new development that happens in the town is done so with regard to that natural, scenic, historic, and rural character of the community, and to do so in a way where the scale of the development was appropriate to the community, that it primarily served local needs, not necessarily regional needs. But of course, that was important for us to consider regional needs when it came to things like affordable housing and other matters. But with regard to things like mining, at the time, under the old zoning, the 1989 zoning law, virtually the entire area of the town east of Route 9, there was a provision in there that allowed mining to occur in that entire part of the town. So more than half of the town was zoned under the 1989 zoning law to allow mining by a special use permit. It also allowed some other things. You could take in, for instance, materials from out of town or from other mine sites within the town, and you could process them within your approved mine site. So those were things that were of some concern in terms of the scale of the overall mining that would occur. So what happened with that recommendation, and it was pretty clear that the comprehensive plan recommends that it be limited to existing mine sites. Okay, there's no sort of a definition for what a site meant. Did that mean the parcels? Did it mean the overall area that was under permit from DEC? That sort of a thing was left vague, and this is the way that comprehensive plans are. That oftentimes the recommendations are left vague so that it can be left to the decision makers in formulating legislative changes to make further decisions and to further refine a broader goal or a broader objective that might be set forth in a comprehensive plan. But in the end, even though there was a lot of controversy, and in the end, I think at one point we had one public hearing close to the end of the process. It was November of 2009, and everything was adopted December 29th, 2009. But at one of the final public hearings, one of the attorneys involved said, you know, I kept count of all the people that got up and talked about the different things that they were concerned about. 18 of them mentioned lawsuits. So this was the sort of context of what happened at the end of the process. But in the end, I think the town board at that time was very comfortable in adopting the documents, all for, well, actually there was more, because there was a seeker finding statement, there was the comprehensive plan, there was the zoning law, there were the subdivision regulations, and there was the wetlands law. And each of them were adopted unanimously by the town board at that time. And I think there was a feeling that what was being adopted at that time was in the spirit of the comprehensive plan. And does that mean that everything that was recommended in the plan was actually translated into the zoning law, into the wetlands law, into the subdivision regulations? No. But that's the nature of planning. That's the way that it is. And there's no compelling reason, just because a plan recommends something, that it be translated into the zoning. These are things that are worked on over time. And as Joe knows, the affordable housing is still not finalized from the 2009 zoning. And that's just an example of something that the town has continued to work on to try and fine tune to get it right. So I think that gives you a little bit of a history of the whole process. And if you have any questions, happy to take them now or
Let me just
Warren?
make a few comments. I'm Warren Raplansky. I'm the attorney to the town, and I was one of the attorneys that worked on didn't work initially on the comprehensive plan, but was the attorney to the town when we inherited the comprehensive plan recommendations from the committee, and worked with Michael Zarin was the other attorney, and with the subcommittee and task force in taking the comprehensive plan that had been developed through this very long, arduous, and I think very good process, and fine-tuning it and dealing with a lot of legal issues that we were concerned about. We wanted to make sure that the comprehensive plan and the zoning law were what we call bulletproof in the event that they would be challenged by various property owners on different grounds. And we dealt with a whole host of issues, and the mining was one of them. There were some other even more significant issues that Ted has alluded to that we dealt with, and we're concerned about finishing the process within a lifetime of certainly certain of the people that had worked on this plan for so long. It took a long time, and we had a lot to complete at the end. Just want to clarify a few things so maybe the public doesn't understand when John was talking about the life of the mine boundaries. I just want people to understand and the board to understand that when DEC issues a mine reclamation permit for a mining operation, one of the things they approve is the map of what we call the life of the mine, and that shows the entire proposed gravel mine over a period of years, which they call the life of the mine. It might be a 5-year plan, it might be a 20-year plan, it might be longer than that. It shows on that plan how the property will be mined over a period of years and reclaimed over a period of years. So DEC, when it's finished with its approval process, creates an approved life of the mine map for each one of these mines. And the mining evolves over a period of years. It doesn't always mining out a piece of property takes a number of years, depending on the size and the type of mine. So what you have on these maps, the gridded areas, show what we've recently been able to map through the aid of a surveyor and engineer, and it was no mean task. What we believe to be the life of the mine boundaries for the Red Wing mine and the Lobotsky mine and the Vonderleith mine, and those are shown on the map. If you look at the life of the mine maps that are produced by DEC, they're really very rarely meets and bounds survey maps, so it's very hard to determine what the boundaries are, and this was a very difficult task, and we've shown this on the map. The red lines are the boundary lines for the overlay mining district as presently exist under the comprehensive plan.
Illustrate for me? You want me to illustrate?
Yeah, if you don't mind.
Okay, so the boundary that Warren was talking about, the overlay district boundary, this is the outline of it here and down here. And then the areas, the life of mine of the 3 mines here, the Vonderleith is right here, this hatched area. This is the Lobotsky mine, and then this is the Red Wing mine up here.
So,
Hey, do you want to put it back so we could share your wisdom?
so just so everybody understands and there's no confusion, the proposal that's before the board, the local law amendment, which would be an amendment to our zoning law to change the life of the mine, the mining overlay boundaries, would change the boundaries from the red lines, which are shown, to the life of the mine boundaries, which are shown. And that's the proposal that's going to be before the board, and it's before the board, and you will have to vote on. With regard to the Vonderleith mine, it's the proposed law would have little or no impact on that particular mine, even though the life of the mine, the mining overlay boundaries seem to be more expansive than the life of the mine for that mine as shown on the map. That area to the west of the mine is wetlands, federal and DEC, and it's not anticipated that you would be able to do any mining in there. So
The DEC doesn't allow mining in wetlands?
Well, it depends on the type of mine. It could be a subaqueous mine that may allow that, but it's usually for surface mines. It's not permitted, and it's not anticipated that if the boundaries were changed to the life of the mine boundaries, certainly for the Vonderleith property, that this law would have any impact whatsoever on Mr. Vonderleith's ability to mine out his approved DEC mine. I just wanted to make sure that that was clear. I'm not sure that the public...
But Mr. Vanderleith has the opportunity at our hearing to say that that contention is erroneous. That's one of the things that I think we've invited Mr. Vanderleith to comment on.
Right, and he may take issue, as you know, with the issue of whether you could actually mine within that additional area, but for the most part, the change in what is permitted on that property was created by the original zoning amendment, not by this zoning amendment. So we want people to understand that, and I also want you to, the public to understand, to a certain extent, the evolution of the mining overlay boundaries. When we were first given the comprehensive plan, when I say we, the consultants who worked on it, there was no mining overlay boundaries in the comprehensive plan, the original version. It simply prohibited mining was taken out as a permitted use throughout the town and in the A3A area. And there were discussions and considerations of what that meant for pre-existing mines and whether there would then be issues and contentious issues over whether those were what we call grandfathered or non-conforming uses. Eventually that plan was abandoned, and a second version of the comprehensive plan, I think in 2008, created the boundaries to the existing mining sites in terms of the properties on which mines were being operated. And if you look at one of the original versions of the 2008 comprehensive plan, you'll see the boundaries of the mining overlay district are actually more expansive than what's shown on this map here. Those actually came out to the edge of the property boundaries. And there was further discussion and consideration about the merits of doing that because of the impact on neighboring properties. Eventually, that evolved to what you have now in red, which is the life of the mine boundary being shown approximately 250 feet from the boundary lines of properties on which there was active mining being conducted at that time. And the reason for that was, one, to protect the property owners by giving a much larger buffer than DEC would have imposed on these, and also to well, I mean, basically that was the reason to protect the neighboring property owners, and to allow for some possible expansion of those existing mines. Now, what you're considering now would be actually changing the boundary lines to retract them and make them smaller, and to limit the ability to mine on these properties in that area to the original life of the mine. And that was certainly discussed in the comprehensive plan. I just want you to understand that your function now as the town board, as your legislative authority, is to consider this zoning amendment on its merits. What you should be doing, and I'm sure you will be doing, is analyzing whether the proposal makes sense from an environmental and community impact and resources protection standpoint. And when you decide whether or not to pass this law, you should be focusing on that, because that's permitted by the comprehensive plan. If you were to leave the boundaries as they are, that's what the town board voted on, and that's what the town board passed when they enacted the zoning law. That's what they created. And the town board at that time felt that that was consistent with the comprehensive plan. If you were to retrench the boundaries, it certainly also would be consistent with the comprehensive plan. But your ultimate decision really should be made on the merits of whether it makes sense from a planning, land use planning, environmental standpoint to make that change. So that's what you're gonna have to focus on. The only other issue I think that was not addressed was the issue about the roads and the bridges. Did you want to?
That's the next topic.
Is that what you're going to do? Okay, so I'll defer to.
Well, let me ask you a question. In the comments we received, there is discussion of grandfathered non-conforming use. I think at least two of the attorneys have taken various views of it. I think the most recent comments that I saw was that it's not for this board to decide grandfathered, constitutionally protected prior use. Is that so? That's not a question before us?
It's not a question before you on the proposed zoning law. The issue of the non-conforming use status of any use that existed prior to the enactment of a zoning law or a zoning amendment is an issue which has to be raised by the property owner. When that property owner goes to apply for a permit or approval and is turned down because the property is not permitted to be used in that manner by the current zoning law. There are certain uses which existed prior to the enactment of the zoning law or the amendment to the zoning law, which the property owner will argue are substantial uses that were built up over a period of years, and as a result of that, they are entitled to protection as a non-conforming use. But that's not an issue for the town board to decide. The way that would come up would be the mining operator would make application under the revised zoning law, the new zoning law, for a permit from the town, and the town would say, no, it's not permitted by...
The zoning enforcement officer is the first person.
Initially, that would be...
And then the zoning board of appeals. It wouldn't necessarily come to us.
That's correct. The application would go to the code enforcement officer of the town, and that person would take the application and say, no, this is not permitted under the law, I have to turn you down. And then they would, if they felt they could make that argument, they would appeal that decision to the Zoning Board of Appeals, arguing that it's a pre-existing non-conforming use, and the burden is on them to establish that. And then the ZBA would have to make a determination as to whether, in fact, it is a non-conforming use of such a nature that, regardless of what was passed by the town board, they're entitled to that. But that's not, you don't deal with that. Town board doesn't deal with that. It would be the Zoning Board of Appeals, and perhaps it would then be a court decision. The court may review the ZBA decision. So nothing that you do when you pass this law will
if we pass this
impact the issue of the
zoning
non-conforming
amendment,
use. Yes.
That's not a question that we should consider.
No. Now, there are ways that you can amortize out certain noxious non-conforming uses. That's a discussion for another day, and that gets rather complex. But that's not what you're proposing to do here. So no, it's not a town board consideration at this point.
Thank you. My third point was the road. You know, if a large mine were to happen here, we've heard a lot of concerns about road safety and the bridge on this road from the neighbors group. What, if anything, could we do to mitigate that?
John.
Yeah.
Well, one method of regulating the intensity of the uses in this area is through the amendment controlling the size of the districts. As you know, mining operations are largely regulated by the state. Localities have been allowed to make decisions about where they want money to take place within the towns. Another area that has been cut out of the state regulatory scheme is regulation over roads. And it's in response to some of the concerns that have been raised about the potential for heavy trucks, high volumes of heavy truck traffic, the potential for the creation of safety hazards as a result of that, the potential for damage to bridges and roadways as a result of that level of traffic. we've developed some initial information, and the board should be aware of the fact that it does have some authority under the vehicle and traffic law to regulate truck traffic on roads. Trucks of certain sizes can be excluded from town roads. Truck routing can be regulated. Weight limitations. These are all things that there is a base of authority for the town to take action on. Under the law, any regulations with regard to road protection have to be reasonable, and they have to have a basis in fact. And so what that means is that if a municipality decides to go ahead and regulate road traffic, you need to have some substantiation, technical substantiation from an engineering study that would verify that trucks of a certain weight would pose hazards, that trucks of a certain weight would pose a threat to the integrity of the road surfaces. Trucks of a certain weight and certain volumes would pose a threat to bridges that are located along the routes. So you would need some kind of engineering study as part and parcel of an action that you would take to regulate road traffic. I know that there is at least one bridge on White Schoolhouse Road, which is a town road, and the town has the responsibility for the maintenance of that bridge. So this is an appropriate subject for you to be considering.
Would that have to be a separate law that we pass, or a separate?
It would be separate, and it's something that could be run in parallel to, it could be a companion to an amendment, a zoning amendment. It could be a standalone law.
So we'd have to hire an engineering firm to do a study?
Yes, yep.
What about hours of operation? Can that be regulated? Hours of use of the road for commercial purposes?
I'd have to look into that before.
Or hours where heavy trucks are allowed?
Yeah, I know that it's possible. There's another section of the B&T law that allows for temporary exclusions of vehicles in order to avoid certain hazards. For instance, if you have a particular time of year where roads aren't suitable for a vehicle, I'd have to look into that.
I assume school buses use that road. It would be nice to keep the trucks off the road while the school buses are there.
Well, that also brings up a point that regulation of the road traffic normally excludes vehicles that are used for, what would be considered to be normal deliveries and activities like that.
Well, we made a list of things we would like to hear from Mr. Vanderleef. I guess I would like to hear what size trucks he uses on the roads, and how heavy the loads are that he's already using, and which way he travels on White Schoolhouse Road. Does he go down to Slate Quarry? Does he go to Route 308? Does he go both ways? And I guess I'd like to hear the same thing from Red Wing as to what size trucks they would envision, what weights, and again, which routes they would take. I think there's some statements, I don't know by whom, and I don't know how authoritative, talking about, I think, 60 trucks a day, but I'd like to get some more information from Red Wing as to what they envision in terms of operations with respect to trucks, assuming that they get the permits that they need.
And can we, as a board, limit what a mining operation would use? Can we say you can only use a small, you can't use, huge dump trucks, just smaller ones to truck out the aggregate?
You can regulate those things if there's.
And then how do we-
basis for doing that.
We can.
There has to be a nexus to the road issue. You can't, and we're preempted, local municipalities are preempted by the mine reclamation law and environmental conservation law from regulating the actual mining operation, so that there are things municipalities can do and there are things that they can't. So when you ask us a question about size or truck traffic, those are not always easy answers. We would have to look into that. But the question about the Red Wing mine, that information probably already is available, because there is a pending application and at least a first draft of environmental impact statement with DEC. And I would imagine that if the record of that application before DEC were reviewed or provided to the town, you could find out a lot of information about what's proposed for that mine expansion. As far as the Vonderleith mine is concerned, there is no application. He has not made any application to DEC or to the town, as far as I know, so we wouldn't have any of that information.
But the neighbors, to a person have said that there's, no issue with Mr. Vonderleith's traffic or the size of his trucks, or with the Labatsky mine by the different people who did that.
You mean current?
Yes, yes. I mean, that's what I heard, that there was, everybody felt that as it existed, it was acceptable, that the concern was, it's fine for you to have, I don't have the same concern that you do, or I don't need the information, because I feel that what I heard was that the Labatsky mine and the Vonderleith mine have been good neighbors.
No, but the information is useful. If there's no problem with the weight of Mr. Vonderleef's trucks, then if Red Wing is going to use the same trucks, there shouldn't be any problem with the weight of the truck. On the other hand, I don't know how many trips a day Mr. Vonderleef's truck makes on that road. That's why I've asked him how many trucks and what is his route, and compare it. He doesn't have to give us that information. Red Wing doesn't have to give us that information, but they can help us to show us if it is in the record with the DEC. You can point it out to us, help us.
So are we able to limit the time of the truck traffic, or,
Again, as far as the road is concerned, you've got to get back to the original reason for regulating traffic on the road, and there is some precedence in the fracking industry for doing that.
Can we consider?
But it has to be from the standpoint of road protection, not from the standpoint of limiting the impacts of the mine.
Oh, so it has to be really road protection and safety, not quiet enjoyment by neighbors isn't something we can regulate for.
You've got to remember, we're not concerned with the existing Vonderleith mine, because nothing in this law is changing or impacting or limiting what Mr. Vonderleith can do for his approved mine. So whatever the truck traffic is, whatever the noise in terms of processing material or whatever else is done, that's a give, and that will continue. I think what we're concerned about on the Vonderleith mine is more, are there plans, or could there be viable plans for expansion beyond the boundaries of the life of the mine? And that's information we...
Well, the other thing is, if we do an engineering study and it comes back and says it should be a 5-ton road and they're using 8-ton trucks, that we ought to know that. The other thing is that, at least when I visited some construction sites, I was told that there were hours that they could work and hours they couldn't work because of bothering neighbors, noise, and the like, and I was told there was a law about that. I don't know whether it's local or state or whatever, but it seems like the same thing.
But that's not a road law.
The problem is that there's no state law similar to the environmental conservation law, which preempts municipalities from acting to regulate the construction industry in that manner, but there is for mining. So that's That's the
Well,
problem.
but trucking, I mean, that's not, trucking isn't mining, is it?
It's part and parcel of mining, but the concern I would have, aside from the road, is the bridge. You should really understand that it is a very, very expensive process to replace these bridges when they go out.
We're almost
so-
done paying one off.
Right.
We know.
So that's something that not only the road, but the bridge has to be focused on to see what the life of that bridge is and the current status of that bridge.
Be interested to find out what this. What about regulating noise of the trucks?
You can get into muffler issues, but usually that's imposed by DEC as part of they usually regulate as part of their permit, the conditions of the permit, they regulate the muffling of the trucks, backup signals, and which can drive you out of your mind.
Yes.
You ever heard that? But that's usually within the province of DEC to regulate. Now, you can weigh in on this, so just so you understand.
The local noise ordinance.
Well, the town is not prohibited from weighing in on the DEC permitting process. You have to understand that even though there's a certain amount of preemption in terms of what we can do in terms of imposing our own regulations, when DEC goes through their permitting process, the town board can involve itself in that process as an involved agency and petition for party status in any adjudicatory hearing or administrative proceeding that's conducted by DEC. So all of those arguments and considerations can also be made by the town in the context of the permit process before DEC.
Yeah.
And that's a way of handling those things. But getting into your own regulations, then you got to decide what you can do and what you can't do.
At
Well, I
what
mean, for
point-
instance, I assume we could pass a law that says no engine brakes are allowed to be used anywhere in the town. I mean, I know there are towns because I
No,
used to
what,
have.
no, what, Alan?
The Jake brake.
Jake Briggs.
Oh,
Yeah, I mean, they're very noisy, and they tend to be on large trucks. There are a lot of, I mean, I used to have a RV that had a Jake brake, and I noticed all these signs that say no engine brakes in a lot of towns in New York State.
Yeah, I mean, there are ways of dealing with those
Warren,
issues.
at what point would we seek interested party status on DEC permits?
As far as I know, for the only application for any of these three mines relates to the Red Wing mine. And the status of that application is that DEC has issued what we call a positive seeker declaration requiring the preparation of a draft environmental impact statement, which needs to analyze a number of significant environmental impacts that they've identified that are associated with that mine. The applicant has submitted a DEIS and has been rejected by DEC. They have to accept it. So they're still going through that process of trying to get the DEIS accepted. Once the DEIS is accepted, then it's opened up to a public hearing process, which may take place here in the town hall. And during that public hearing process, issues would be raised by DEC, by the town, neighbors, or other interested parties as to environmental issues which they feel have not been satisfactorily resolved in accordance in that application. And then a decision would have to be made by an officer, a hearing officer who's actually works for DEC, as to whether there are issues which require what we call adjudication in a formal hearing. And they would take testimony on that preliminary issue and then issue what we call an issues ruling, and then determine whether there are in fact sufficient issues to warrant an adjudicatory hearing. And during that process, the people who want to petition for party status to allow you to intervene, and you have to make a showing that you have a real interest in the application, that you have sufficient resources
So
to
the-
really
the
involve.
town board-
The town board could do that. I've done that for other
The
towns.
town board would do it, and it's after the draft environmental impact study is accepted by the
It's
DEC.
accepted, yeah.
If it is accepted.
Well, at some point.
It will be?
Probably, I mean,
Okay.
you have to figure that they'll keep addressing the concerns of DEC and keep resubmitting it, but at some point, I would imagine it will be
How long
accepted.
has this been going on? How long has the environmental impact statement?
That's been a
Process.
while. Do you know how long?
Over years.
Yeah, it's
7 years.
The Red
7
Wing,
years? Really?
the DEC hasn't accepted it in 7 years?
Well, the process has gone on for 7 years. I don't know when the first submission of the DEIS was
That's
made.
close enough. Gee, okay.
But it's a long time. It's a long time.
Under the present regulatory scheme, do we get automatically copies of filings with the DEC with respect to Red Wing? Or how do we find out about it? Just keep our nose to the ground?
There are certain things I think that DEC supplies the town with and probably have sent things to the planning board. There are other things that you have to ask for or FOIL or make requests for. You have to keep your nose to the ground. You really have to keep on top of it and periodically check
Check
the
the-
DEC. In the old days, we used to go up, I don't know whether you have any experience with this, but we used to go up and actually pull the files out and examine the files. They don't do that anymore. Now you FOIL what you want and they provide you with that information. But you can't take anything for granted. You have to keep, that you're going to be notified. You have to, there are certain things that they will notify the town, but you have to keep right on top of the application.
I thought in the DEC process that there's a 30-day window where they go back to the administrative head, I think it says, of the town, and ask for any of these stipulations like traffic and everything else. That's what I read. So who's the administrative head?
Yeah, there is for issues which are preempted and issues which the town still has some jurisdiction and say over, they will ask the town for recommendations about what they would like to see happen. So say the town doesn't have the jurisdiction to impose a restriction, they may want DEC to impose a restriction, then there is a request that's made. That's probably already been made to the town. That's usually at the incipient stages of the process.
In that part of the process, it's one of the questions that they ask the town is mining permitted in this area?
They do ask that.
And so, but it also says things like traffic and everything else in there, and if that's already passed,
No, the time has, that's just at the preliminary stages. Those issues, especially in a large-scale application like this, that's DEC is taking very seriously, that there will be a time to weigh in on those issues.
okay, so who's the administrative head?
I imagine it would be the town board and the town supervisor that it's sent to. It's usually sent to the town board, town supervisor.
I'm sorry, I didn't hear.
Town
Go to the
supervisor.
What?
The communications from DEC initially, or copies of correspondence, et cetera, to the-
I get them frequently.
Town supervisor. And if the planning board, for instance, has commented on a particular matter at an early stage in the process, DEC will typically also copy the planning board on the correspondence. And I believe they've done on a couple of occasions with regard to the preliminary DEIS, the comments on the preliminary DEIS.
Just so everybody knows, this is Art Broad, this is the town's planner. Have they been keeping the planning board informed of, has DEC been keeping the planning board informed of what's been?
I believe so.
There hasn't been anything since I've been supervisor.
I don't think
Other
anything's
issues,
happened in a while.
I've been getting,
Nothing initiated.
no, I've been getting communications from them on other issues, not having to do with mining.
But just so you know, you mentioned the thing about zoning. One of the oddities of the process is that DEC will ask whether zoning is permitted, but it makes no difference whether it's permitted or not permitted. They will still process the application even if it's not permitted. there's been a lot of criticism of that, and, but that's the way it works.
Well, because, yeah.
Is there anything else that we've answered your questions?
Does anybody else have any questions that they want? What's our next step?
I think that I was told that you were interested in rescheduling the public hearing. I don't know, I don't think there needs to be any modification or change in the language of the substance of the law, but there may need to be some tweaks made in certain sections of the law in terms of the purpose. Is that something you think should be done before it goes back for the public hearing?
I think in the long run, it probably makes more sense to do that sooner rather than later.
So let's get that
Oh,
done.
but don't you need some kind of guidance from the board as to how we feel? You know, you're going to draft something. We have I think language of the amendment is to substitute the map before you start drafting a lot of verbiage in front of that.
That's up to you.
Well,
I don't think there needs to be much of a change in the substance of the law, but if you want to set it down for a workshop so we could go over that with the town board, maybe that would make sense before you reschedule for a public hearing, and then...
If you want to listen to more public comment before you take any steps in that direction, you can do that too.
I know, I would prefer to hear the public. Public has heard this presentation to us. I'd like to hear comments. We've raised some questions. I'd like to hear what the public has to say about it before I think we take another step.
So let me make a suggestion. Reschedule for the public hearing. We won't make any changes to what's there now. See what the public comment is, and then you can decide where to go from there.
Does everybody agree with that? Do we want to have, so we want to have another public hearing to get answers to our questions or any other public comments based on this, and then we'll have a workshop to look
Well,
at...
let's decide after the public
Yeah,
comments.
let's see what the reaction is.
Well,
In
the
parallel,
answers
we
to the
wanna-
questions may come in the public hearing.
I'm sorry, I didn't hear what you said, Bruce.
The answers to the questions may come during the
Yeah,
public
I
hearing.
assume they will.
Or not. The other thing is, do we want to commission an engineering study of the road?
No. Do we?
Why not? I mean, if we're gonna look at putting speed limits and weight limits and blah, blah, blah on the road, we need the engineering basis for it.
I think the first that you might want to put out an RFP for an engineering analysis of both the road and the bridge, and see if you can get a firm that actually would do both, and see what the costs are. That might be a good idea.
You want to do that after a public hearing, or do you want to get started on that?
Well, you got to do it in parallel, I think.
Yeah, I think we probably ought to get started on that, because I kind of think whatever way we go,
We just,
we're going to need that.
I can give you one that we just did in another town it was a bridge issue, but you can probably kind of follow it for...
It's an
Do
RFP.
we need an RFP, or can we contact 3 firms?
You can, because you can contact, but I think if you define the scope of what you're looking for, it doesn't have to be put out to, competitive bidding, but I think you might want to, the RFP can be as simple as a 2 or 3 page document, just describing what you're looking
Written
for.
quotes. That'd be 3
I can make it as
written quotes.
For me,
complicated.
a simple document.
There's no way to make a simple document. I can show you.
2 pages.
I'll send you what we did for another town, and you can take a look at it and see if you want to kind of do that. And then you can actually just send it to 10 engineering firms if you want, but it makes sense to send it to firms that have an expertise in bridge and road stuff.
Nice, yeah.
do we want to notice for our public hearing? We need 10 days.
Is there anything else that you wanted to, did you want to say anything else? No.
Is the 23rd too tight, John?
I think so, yes.
Okay.
We have a town board meeting.
Weren't you talking about March 9th or something?
Well, that's a town board meeting. Do we want to do it on a town board meeting or on another night? Anybody?
I'd go for the town board meeting.
Okay.
I would like to do it before the 11th of March.
Would you consider doing it on the 16th?
Of March? I'm not going to be, I'm going to be away.
Let's do it, how about if we want to do a town board meeting, it has to be the 9th. If we want to do it sooner than that, it can be the week of the 23rd or the week of the 2nd, which will give us enough time to publish, 10 days to publish a notice.
The 2nd,
Be away on the
I mean, I can certainly be there on
No,
the
I'll be
2nd.
here
I
on the
think
9th.
that-
I'm going to be away on the 11th.
We can't do, I have a calendar here, Art, of the town hall. We can't do a Monday night that isn't a town board meeting because we could do the 26th, which is a Thursday,
26th of what month?
February.
Of February? The 20, what is it?
That'll work.
Sorry, there's
I can do
there's
it.
sorry, there's
The 26th of February?
there's a justice court that night.
Yeah, I can't do the 26th of February, let's see, I'm
How about the
confused.
25th?
So Wednesday
That's
night?
reserved for a justice court. Do we know if they're,
The court on Thursday is usually done by 6 or 6:30.
all right, then let's do it on the 26th,
What day?
Well, Joe said he couldn't make it.
What, 25th or 26th?
26th.
I can't do it 26th. I can do it 25th.
The 25th?
Yeah, so can I. Well, there's a rec committee meeting that day.
It's a Wednesday.
How's that, 25th?
Not good for me.
That's the 24th.
24th, I got
Tuesday.
something, wait
I
a second.
can't do 24th.
I have
Bruce,
another hearing that night.
you'll roll with it?
Yeah, I'm available, I'm available. I don't understand why we do it ahead of the 9th, though. That's what I'm
You want to
missing.
do it for the town board meeting on the 9th?
That's what I'm not understanding.
Yeah, I agree.
What month are we talking about?
March 9th, we'll do it at we'll notice it for March 9th at our town board meeting.
Okay, I have
And we'll
another,
have John here,
yeah, you
yeah.
know,
Good.
Good? I'll work with John to figure out what time during the town board meeting. John, that's good with you?
Can you be here?
Yep,
Okay.
I can do any time.
Okay.
So you need a resolution continuing the, recommencing the public hearing on local law, what are we calling it?
Is that continuing the public hearing?
On the local law number A, letter A.
We haven't assigned it
Yeah.
a number.
For March 9th, at what time? 6?
I said I'll get with John to, do we need to do that now? Okay, then 6:45, you like to do it at the front, right? 6:45, does that work for everybody?
It's great.
Bruce, the voice of reason, stick to the town board meeting nights.
figured out what the
How did we
problem
miss
was.
that one, yeah. Yes, I'll motion that. Do I have a second?
Second.
All in favor?
Aye.
Aye. Any opposed? So moved. Thank you.
Motion to adjourn?
I'll make a motion to adjourn.
I'll second it.
All in favor?
Aye.
Aye. Thank you.